The House Committee on Redistricting will come to order. The Chair welcomes our members, invites them to take their seats. We welcome our guests who are here. Special appreciation, as always, to our staff in setting up and helping us conduct this meeting. For your planning purposes, the intent of the Chair today is to review the concept of drawing districts. There are 3 bills. We have invited the bill sponsors to give a brief overview of their bills. We're then going to ask staff to do a compare and contrast of the bills. I think it's important to understand that the concept of districting and people being able to elect the person of their choice to represent them in their legislative body is as old as our republic. And it is a fundamental principle that we find a way to maintain the integrity of the process of creating those representative districts. With that being said, it's the Chair's intent to recognize Representative McGrady to discuss briefly House Bill 140. We're also going to ask Representative Warren to present his bill. Representative Reeves let me know that he had a commitment that arose this morning, but he will get a chance to speak in future meetings of this committee. After that, we're going to turn to Ms. Churchill, who's going to go through a compare and contrast of the bills that are before us. Then we're going to turn to committee discussion. It's the Chair's hope that through this process we can recognize concepts that unite us, things that make sense in potential redistricting reform going forward, and we can also perhaps recognize challenges that need to be addressed or may stand in the way of making progress on this very important matter. With that being said, for a brief presentation on House Bill 140, Representative McGrady is recognized.
Thank you, Mr. Chairman, and particularly thank you for convening this meeting to talk about the broad concepts here. I too have spoken with Representative Reeves. I'm a primary on both of those bills, and so my remarks actually will try to compare and contrast a bit both of those bills. I'm not intending to be an advocate for either of the bills, because I really think at this point, if we're going to move forward on this issue, we need a bipartisan coalition. There won't be any confidence in it if it's one bill or another where we've divided along party lines, and so I think it's critical that we just understand the various options. House Bill 69 and House Bill 140 both have as their primary goal to establish a nonpartisan redistricting process. 69 is a statutory approach. House 140 is both a constitutional amendment and a statute. House Bill 69 leaves the final decision with the legislature, but maps are drawn by an independent commission. House Bill 140 leaves the final decision with the legislature, but the legislative maps are drawn by legislative staff. Both bills have a set of criteria that are to be used, whether by the independent commission or by the staff, and the criteria are similar, but they're not exactly the same. Both bills try to exclude information that of a political nature that can be included for whichever group of the map drawers there are. I would tell you there are advantages and disadvantages to both of these bills. House Bill 69, actually, the House passed in 2011 a version of House Bill 69. It never was taken up by the Senate. I've introduced House Bill 69, or a cousin to it, in each of the last few sessions. This year, working with Representative Reeves, we put forward 2 proposals. And these 2 proposals have over half of the House supporting one or both, well, both of them, but a different set of legislators. Sometimes legislators have co-sponsored both bills, sometimes just one of the 2. But the support for the concept of redistricting, nonpartisan redistricting, is clear. Quickly to the advantages and disadvantages. House Bill's disadvantage and advantage is that it's a constitutional amendment. Constitutional amendments are hard to pass, and once you put them in place, they're really hard to change. So if you made a mistake of some sort, or you want some clarification, that's going to be a tough act with a constitutional amendment. Statute, same advantages and disadvantages. For some people do not want to pass a statute that can be passed this year, and then 2 years from now, when some group ends up back in the majority or not in the majority, they're dealing with a statutory approach. House Bill 140 actually has both a statute and a constitutional amendment together, but obviously the statutory piece could be changed. One thing I constantly hear is that, and as the reason why we haven't passed House Bill 69 the last several years, is the whole concept of unaffiliated voters. I know a lot of my colleagues who do not believe there is any such thing as an unaffiliated voter these days. And so trying to figure out how you set up a commission or a process that engages unaffiliated voters or minor parties is tough. One of the real difficulties is, what is the legislative role? I heard from 3 different people yesterday, constituents of mine, that I want to get the legislature out of redistricting. Well, that's not going to be possible unless you pass a constitutional amendment, because at this point in time, our Constitution provides that the legislature has that role. We can limit that role in some fashion, but you limit it by statute, and the legislature can come back and change the process. I want to point out one thing, and this is, if there's one take-home from my comments, and then I'm going to let staff do the comparison after hearing from Representative Warren. These 2 models, 69 and 140, can be combined. If you look at 140 on page 3, lines 10 to 11, a constitutional amendment will likely need a statute to fill in the gaps. And so I would suggest to you, and you'll note in this 140 actually sort of references 69 in those two areas. And so when we get to the comparison point, I'm sure Erica Churchill will take a deeper dive into what the criteria might be, what the process is. There are a myriad of different options, but before we get there, we need to have a firm commitment that we're actually going to do something about partisan redistricting before we start fighting over what the details might be. Thank you, Mr. Chairman.
Thank you, Representative McGrady. Representative Warren, would you give us an overview of House Bill 648?
Thank you, Mr. Chairman. First, I'd like to say that I'm probably listed in that group of people that, and I want to clarify, I do believe in unaffiliated voters. What I have a difficulty in accepting is a nonpartisan entity. And I think there's a clear distinction between that. We've had a lot of partisans here lately. They've migrated from their political party affiliation to an unaffiliated status, but it doesn't mean there's not partisanship involved. And what I seek to do here with House Bill 648, is not to limit the GA's role, but to assist the GA's role. We have a constitutional authority and a right and responsibility as elected people representing in the House 79 to 82,000 people. For us to relegate our responsibility when it comes to redistricting to either legislative services or to a commission, I think is a dereliction of our duty. What House Bill 648 does is incorporate some of the better aspects of the other two bills, H-140 and H-69, yet it streamlines the process while retaining our constitutional responsibility of the General Assembly in regards to redistricting, and it provides for an objective drawing of legislative and congressional maps as much as humanly possible. It creates an independent redistricting commission, similar to what H-140 creates with the temporary redistricting advisory commission, and H-69 creates with the nonpartisan redistricting commission. However, it's not intended to be an unlimited term as in H-69 or unspecified as in H-140. The independent redistricting commission in HB 648 is limited to the date that a plan is approved by the General Assembly. The proposal includes a more detailed process for committee nominations and alternates at the same time. It also seeks to streamline and expedite the process for the nominations. Like H-69, if when the nominations and their qualifications are verified by the state auditor, in H-648, nominees for the Independent Redistricting Commission are validated through the State Board of Elections. If you were to follow the process in HB 69 and a plan is submitted and doesn't pass, and the second plan is submitted and doesn't pass, and you go to the third plan, which goes to the entire process for the dates and times that are specified in that bill, would drag that process out to at least 114 days, or about a third of a year, just to get a set of plans done. So what I seek to do in H-48 is, bearing in mind that ultimately the plans that aren't approved in the other two bills ultimately ends up back in the General Assembly. We just kind of cut to the chase here with HB 648. The commission that is created in this bill is, and if you haven't had a chance to see it, you really need to get into that. The way the committee is devised is about as nonpartisan or consensus-based as you can get, but they will select a special master to draw up two sets of plans for each of the congressional districts, the House, and the Senate. And the commission will decide between the two plans for each set which plan to submit to the House and to the Senate. And those plans will then go through the normal committee process that we have here. And one thing I would like to do with this bill at some point is to clarify and specify that as it goes through the committee process, it shall have time allotted for public comment. I think the process in H-69 going through at least it says it mandates at least 21 public hearings across the state. I think it drags the process out. I think there's a better way to get public comment, and I think we touched on that in the last round that we had here a few weeks back with addressing the court mandate for the 14 House districts. We can offer transparency and an opportunity electronically for people to participate across the state. If you're going to do it remotely, then why 21? Why not 100? We have 100 counties. People might not be able to make it to one of the 21. But everybody should be able to find access either by telephone or through the computer to access the committee or to even tune in online to listen in on a committee process. So this proposal is cleaner, less complicated than the other two proposals. It provides for transparency and for public comment through the committee process rather than the remote hearings. And the voice of the general public is not muted or stifled by removing the General Assembly, either chamber, out of the process. By keeping the committee process in place, we have an opportunity to participate in the process. And that concludes my presentation on the overview.
Thank you, Representative Warren. Members, for your planning purposes, we're going to need just a moment as staff sets up for their presentation. We're going to invite the public to view along with the screen as to a comparison chart, but in just a moment we're going to recognize Ms. Churchill and Ms. Hawkins for a presentation of the compare and contrast of these three bills. And Representative Warren, in no way was the screens lowering down meant to shorten your presentation. I'm sorry that took place in that particular order.
It was an improvement over the shepherd's hook.
In church, they start turning off the lights in the choir, but that was not my intention. Ms. Salmons, Ms. Churchill, at your convenience, you're recognized to begin your presentation. The chair believes that we do have some extra copies of this chart. If we could direct our Sergeant at Arms or our staff to get those to the public in the back of the room. First of all, before we begin, do members have a copy of this report? If you don't, please raise your hand. We'll take care of that first. The Sergeant at Arms can make sure all the members in the room, even those that aren't on the committee, get one, and let's get the rest to the public in the back of the room. And again, it will be on the screen. Let's get it to the press as well if we have any extras. If we need to go make some more, we can. Representative Butler for an inquiry. The lady's recognized.
Yes, sir. Mr. Chairman, first of all, I would like to applaud you for the opportunity to evaluate these bills. I think this is a long overdue step in the correct direction. So again, many thanks for this opportunity. I did have one quick question. I know that there was one additional redistricting bill, number HB 827, that was filed this session, and I just wonder why perhaps we weren't evaluating all four of the bills and chose these three. But again, please don't take the question in any adverse fashion. It's just that we did have four filed, but again, very happy to be here today, sir.
Yes, ma'am. I'm not intimately familiar with House Bill 827. These are the three that seem to have had the broadest number of sponsors, and so these are just the three that we're starting with. In no way should you interpret that these are the only three concepts that'll be discussed.
Thank you, Mr. Chairman, very much.
Thank you, Mr. Chair. Jessica Salmons, Legislative Analysis. I'm going to kind of go over the chart that is on the screen up here and that you have in front of you. As I begin, there's a couple of different topic areas. The first is kind of the way that this is drafted, what it would apply to in terms of, is it statutory or is it constitutional, and then what districts is it applying to, and then you get more into the makeup of the commission, and then you get into the actual legislative process for how the bills that embody these plans would be enacted. So that's kind of the topic areas that we'll quickly go over to compare House Bill 140, House Bill 69, and House Bill 648. As Representative McGrady mentioned before, House Bill 140 does have a constitutional amendment component as well as a statutory component. The constitutional amendment would actually be on the ballot for the voters to vote on at the March primary in 2020. And then there is a statutory component to that bill that would come into effect upon the ratification of that constitutional amendment if it is approved by the voters. House Bill 69 and House Bill 648 just have a statutory change, creating a new article in Chapter 120. There would not be a constitutional amendment to those particular bills. How these bills are drafted, they apply to different electoral districts. House Bill 140 is the most broad, and that it applies to any electoral district established for House, Senate, Congress, local boards of education that have been established by local act, and any unit of local government in the state established by legislative act. Yeah, it should be on there. And House Bill 69 and House Bill 648 just apply to any electoral district that is established for House, Senate, and Congress. Those two bills are silent as to any other electoral districts. When you kind of look at the redistricting standards for each of the three bills, some of the language is slightly different, but overarching it's pretty much the same in terms of what it's trying to get at. Some of the actual individual words used, like I said, slightly different, but they would in effect do the same thing. Some of these redistricting standards are actually based on our current constitutional requirements in place. Districts must be based on population. They must be drawn in a manner that complies with the requirements of federal and state law, which kind of gets into the districts that you have to draw first to comply with federal law. You would have to draw those districts first and then draw the districts that there's no requirement there. To the extent consistent with other standards, districts must coincide with political subdivision boundaries, and divisions of those boundaries must be minimized for counties, cities, and VTDs. So it's putting in the standard of minimizing split VTDs and split municipalities. And for legislative districts, the whole county requirement that's currently in the North Carolina Constitution must be complied with to the extent that you have to remain consistent with federal law. Districts must be composed of convenient contiguous territory. Districts must be reasonably compact. All three of the bills have two different tests listed to measure compactness that are the same. Districts must not be drawn to favor a political party, any incumbent, or any other persons or groups, or to augment or dilute the voting strength of a language or racial minority group. The addresses or geographic locations of incumbents may not be used in drawing the plan. And then, except to the extent required by federal law, the political affiliations of registered voters, previous election results, or demographic data other than population head counts may not be used. So like I said, those are pretty much the same for all three bills in terms of what would be required of whoever's drawing the plan to use as their standard in drawing that plan. Where the bills start getting different is with the actual commission itself, what that looks like, who is appointing members to the commission, and then the function itself of the commission. So starting with House Bill 140, the statutory component of this bill would create a 5-member temporary redistricting advising commission, and the way that this would work is the President Pro Tem of the Senate, the Speaker of the House, the Minority Leader of the Senate, and the Minority Leader of the House would each select a member to be part of the temporary redistricting advisory commission. So that would create 4 members, and then those 4 members would then select a 5th member who would serve as the chair of the commission. The House Bill 69 creates an 11-member nonpartisan redistricting commission, and the way that this one would work is the President Pro Tem of the Senate, the Speaker of the House, the Minority Leader of the House, and Minority Leader of the Senate would each create a list of 10 potential nominees that are affiliated with their political party, and then they would separately create a list of 3 people that are not affiliated with either of the 2 majority parties. The Office of the State Auditor would then take those lists of the 4 separate lists of 10 nominees and pick through a random draw done in whatever process the state auditor chooses, a random draw of 2 from each of the list of 10 to actually be on the commission. And then they would take the combined list of not the 2 major parties, and take that list, combine all names, so you end up with 12 names, and then do a random draw to select 3. So you would have 3. You'd end up with essentially 8 members that are of the 2 majority minority parties, and then 3 that are not affiliated with either one of those 2. The House Bill 648, 16-member independent redistricting commission. This is made up of 11 voting members and 5 non-voting alternate members. So it automatically creates a process of filling a vacancy that might be created by a voting member, but having someone that's already been serving on that commission kind of step in to fill that vacancy versus appointing somebody new to the commission. The way this would work is the minority leader of the House, majority leader of the House, minority leader of the Senate, majority leader of the Senate would each appoint 2 people to serve as a voting member and then 1 person to serve as an alternate member that is affiliated with their political party. So then you would end up with the majority leader of the Senate appointing 2 voting members and 1 non-voting alternate member to serve as an alternate for those 2 voting members. Once you end up with your 8 voting members that were appointed by the selecting authorities, those 8 members would then come together and select 3 unaffiliated individuals to also be on the committee to make up the final makeup of the commission. So getting into the role of the commission, what the commission would do, the Temporary Redistricting Advisory Commission in House Bill 140, their function would be to actually give guidance to the Legislative Services Office, who is actually going to be the one drawing the plan. In this bill, they would adopt policies for the release of information to the public, and they would be the entity that would schedule and conduct public hearings and kind of receive testimony from that public hearing to submit to the General Assembly. The Nonpartisan Redistricting Commission in House Bill 69 would actually be the commission that would prepare and propose plans for revising legislative and congressional districts. So they would actually be the ones drawing the plan. And then the Independent Redistricting Commission in House Bill 69, their function would actually be to select and contract with a special master. There would be an interview process. They would interview for the position of special master, and then the special master would actually have to follow the redistricting standards to draw the plans, and then the commission would then take plans proposed by the special master and vote on that to submit to the General Assembly. Which kind of gets into the next thing I already kind of talked about, the drawing of the plans and the approval of the plans. Again, House Bill 140, the Legislative Services Office would be the one drawing the plan and then submitting that to the General Assembly. House Bill 69, the commission, again, would be the one drawing the plan, and then the commission itself would have to vote on the plan by a vote of 8 of the members. The special master in House Bill 648, like I said, would be the one drawing the plan. And that bill, the special master would submit the plan to the commission. The commission would have to take a majority vote to approve it, and then would at that point submit it to the General Assembly. So in all of these instances, whoever is approving the plan, or the one actually drawing the plan, with the case of House Bill 140, would take the plan essentially and submit it to the General Assembly through the principal clerk's office, and then they all require a member to at that point file a bill that embodies the plan that's been drawn. Then you're going to get into the legislative process, what actually takes place after a bill has been filed with one of these plans in it. The The process is different for each of the three bills. House Bill 140, at the time that the first plan that has been drawn by the Legislative Service Office is before the General Assembly, that bill, at the first time that happens, no amendments other than like purely corrective amendments would be permitted. If at that point it fails to pass a second or third reading in either chamber, it would go back to the Legislative Services Office to do some kind of revision to the plan, and that would have to be done within 35 calendar days, resubmitted to the General Assembly. But at that point, the bill would be voted on through any other legislative process here, meaning amendments could be offered on the bill. With House Bill 69, it kind of follows a similar path, except there's one more plan that could not be voted on except for, or could not have an amendment offered except for a purely corrective amendment. So the first plan, no amendments other than corrective amendments would be permitted. The commission would redraw if there is some kind of lack of majority vote. It fails on first or second reading in either chamber. The commission would have 35 calendar days to submit a second proposed plan to the General Assembly. Again, no amendments other than corrective amendments would be permitted. If that does not pass on second or third reading in either chamber, the commission would submit a third proposed plan, and that third plan would be just like any other bill here, meaning amendments could be offered. House Bill 648, when the commission kind of proposes a plan, it is filed here by a member, that would be treated as any other bill. There's no requirement in the bill itself that amendments be purely corrective, meaning it leaves it open for members to propose amendments to the bill at any time. The last kind of topic area is public hearings. House Bill 140 requires at least 3 public hearings. House Bill 69 requires at least 21 public hearings. Half of those would have to be before the plan is drawn, and then half would be after the plan is drawn. And then House Bill 648 is silent on any required public hearings. I think that covers everything.
Members, we're going to move forward with questions for our presenters. Let the chair qualify that by saying that this is a big topic, and it's entirely reasonable to expect that there may be some questions that are asked of our staff today that they're not going to be able to respond to today. But we do need to get these concerns out there, and the next time we meet, perhaps we can get a response to those. So if you're asked something that you need more time on, just say that's what you need. The chair has a series, and I'll start. First of all, when the census is conducted, how long usually does it take for the data to get back to the General Assembly and to the public to be considered?
So with the Census Day is on April 1st of the 0 year. Under the federal law, generally, the U.S. Census Bureau starts returning the results of that census to each state. Every state does not get theirs on the same day. It is a series of rollouts. The time period is December of the 0 year through March 31st of the 1 year. So the last possible time that we would receive it would be the March 31st of the 1 year. There have been years that we've gotten it in February. There have been years that we've gotten it in March. I'm sure there could be a year that we get it in December.
An additional question on the census. Is there a process in place, or are you aware of times in which the census numbers themselves have been challenged and needed to be revised?
Absolutely. So the U.S. Census Bureau does have a process that allows any municipality, any county, any state to say, you got our count wrong. And it does take a while throughout the decade for that to work through at the U.S. Census Bureau level. It is on them. And that is their rules, their process. How they choose to do that for the next decade, they'll set up and let us know. But yes, there have been, at least in the 2000 decade, I believe it was, we got updated numbers mid-decade.
So to follow up on that question then, you said we got the revised numbers mid-decade. Is there currently any statutorily established time for after the release of the census data that the new districts need to be drawn?
So I think the answer to that might turn on which kind of district we're talking about, and whether or not it has an impact on it, which again may be controlled by some of that U.S. Census Bureau policy. So if I remember correctly, mid-decades, and this may be one of those things we need to go back and actually clarify my memory, it was an issue with one of our university towns, that something went wrong with the count on campus. And it did not impact the redistricting, but it did impact, so the Census Bureau, the results of the census has two distinctly different meanings and two distinctly different applications. One is districting, apportionment of voters. Another one is release of federal money, designated by population. And that's what that particular one affected. If for some reason it did impact some sort of district population, apportionment of population for voting purposes, under the North Carolina Constitution for North Carolina House, North Carolina Senate, the constitutional provision currently requires that it only be drawn upon the return of the federal decennial census. The only other time the General Assembly has the authority to do anything is when the court orders it.
So to be clear, we have to have the decennial census numbers back by March 31st of the 01 year, which I understand that. Is there a date certain then after that the districts that we are absolutely tasked currently with drawing, which are State House, State Senate, and U.S. House, is there a date certain by which those must be drawn?
Currently, no.
Okay.
But there's then the practical implications of you can't file for office until you have the new district.
Sure.
Right now, statutorily, the filing period for House, Senate, and Congress, unless there's additional changes by the General Assembly, would be in December of 2021. So your kind of window of time would be from the return of the census and when those numbers could actually be inputted into some sort of mapping system, and the opening of the filing period in December of 2021.
Relying on your knowledge of past actions and recognizing from the chair that there's been times that redistricting may have been done in a local area that wasn't necessarily requested by the local area, how often have you seen the General Assembly asked or staff tasked with voluntarily, if you will, redrawing county or city lines of some kind?
That's probably one of those we can go and do a little bit of research and get you some actual numbers. But generally, I'll say, so we've got roughly 530 some cities in this state, and we've got 100 counties. We also have, I believe it's 114 or 115 school boards, all of which may be subject to local districting. I would say we maybe see less than 10% of those each decade, because for the most part, the locals make their own decisions about what their district plan is, and some of them don't even have districts. They're still voting at large.
Would I be correct to say that the drawing of judicial election districts don't exactly follow the same steps that other election districts do?
Absolutely. We have a series of cases here in this state that would say that the criteria used for drawing of judicial districts takes into consideration a set of different factors than you would take into consideration for an elected House, Senate, or congressional seat. One of those being workload, the public who is subject to the court system, how long it would take them to get to the court system, that kind of thing. At this juncture in time, our judicial districts have been changed kind of periodically. They have not been whole state redrawn in a period of time, it's probably 2 to 3 decades.
This next one may be one that we'll need to get back to the next time we meet, but one of the things that Ms. Salmon said in her presentation was compliance with federal law. Do we really know exactly what that means?
We will definitely be happy to try to pull together some information for you. The first thing that comes to mind is the Voting Rights Act of 1965. That has broken down into basically Section 2 and Section 5. Section 5 was our pre-clearance, where we as a state had to seek pre-clearance of anything affecting voting rights of any person in the state in 40 counties, because those 40 counties were deemed under a test in Section 4 to have been engaging in behavior that the Voting Rights Act deemed inappropriate at the time it was passed. That Section 4 test was declared unconstitutional by the courts. So there is no new test that Congress has put in place. So Section 5 at this juncture in time really has no application. Section 2 continues to have application to the entire state, to every state in the nation. And it basically turns on a series of tests as to whether or not you have a voting block. And so that piece of it changes as the federal case law changes. There's some additional federal case law about the one man, one vote interpretation, that kind of thing. If you'll remember, if anyone was here back in the 1 year or the 16 year when the congressional plan was enacted by the General Assembly, those 13 districts have to have exactly equal population. And that's a series of case law at the federal level that's not applicable at the state level.
All of the plans speak about making efforts to be reasonably compact. This may be something you have to get back to us on. So I guess this is a two-parter. Do the bills speak to any kind of specific test of compactness, or could you speak in general terms about what compactness means?
Again, we're happy to come back to the committee with probably a little more substantive answer to this one. But generally, compactness is it is the district, if it's meant to serve 100 people, does it cover a square miles of 5,000 square miles versus 5 square miles? The tests that we currently have within our mapping system include the Polsby Popper, the REOC, and a couple of others. For the last 2 districtings, the General Assembly has used the Polsby Popper and the REOC as the standards. But that would be up to the General Assembly through statute or through adopting criteria for each committee to determine which one they wanted to use.
The chair has a couple more, but don't want to monopolize all of the time. So let's turn to the committee for questions that they may have. The chair saw Representative Szoka's hand. So for inquiries to our bill presenters, the gentleman's recognized.
Thank you, Mr. Chairman. The first question I have, and it might be for Representative McGrady, I'm not sure, on House Bill 140, on the summary sheet here, under application, it says any unit of local government in the state. So am I to think that that would apply to municipalities? Because I don't see that in the bill. I'm just...
I'll say, Representative McGrady, if I might, that is our mistake. So the way the bill is worded, it would, in the Constitution, it would actually say that any legislative act. So the only time it would apply to those local governments would be in the instance, as Representative Lewis was referencing. Sometimes the General Assembly does by local act district.
Follow.
Gentleman's recognized.
All right, thank you for that. That cleared that up. The second thing I have in the redistricting standards, all 3 of these and the bodies of the bills say districts must not be drawn to favor a political party, incumbents, or other persons or groups. Can you define groups for me?
No.
Well, my comment on that would be that if I, Mr. Chairman, might have the permission to give an opinion here rather than just a question?
You do, but would you restate exactly where you are? I was trying to follow you, Representative, and I,
Yeah, yes, sir. I'm on the summary sheet on redistricting standards. And all three bills, it's the big block in the middle on one side of the page. About
and you
the
are
sixth bullet down.
group, the
Groups.
word groups is what you're asking about, right?
Yes, sir.
Please proceed.
Groups could be defined as farmers. That could be a group. And this leads to a bigger question of rural versus urban. I've talked to some members of separate groups. I represent mainly a rural area right now, and the areas that are suburban used to be rural. So my concern on no real definition for groups could be used inadvertently to be used against rural areas, farmers who have certain interests, which leads to a larger discussion is why is that important and how does it relate to compactness? And I'm going to use Cumberland County as an example because that's where I live, that's where I represent, and Representative Floyd's here. If I go wrong, feel free to interrupt and correct me. But the geography of Cumberland County basically is consider a rectangle with the city of Fayetteville in the middle and extends out. You have the Cape Fear River, which essentially comes down through the middle of the county. Everything east of the river is rural, and you have 7 small towns over there which have different distinct interests from the city of Fayetteville. I could go in with any of these bills the way they are, and I could draw pie-shaped wedge districts which would include parts of the city of Fayetteville and then parts of rural areas. Because of the density, you'd probably have more people in the urban areas of Fayetteville, and then this needs to be tightened up somehow in any one of the 3 bills, I think, because what you have is people of similar interests. Again, farmers, more rural areas, and you have housing developments out there. But trust me, in Cumberland County, they think more like each other, irrespective of Republican, Democrat, unaffiliated, in the issues that are important to them than they do on many issues that are important to the residents of the city of Fayetteville. And what I'm saying is by no means a slam on either group of residents. It's just an acknowledgement of the fact of life. That, and I'll give you an example. Water sewer lines. In the city of Fayetteville, the Public Works Commission is owned by the city of Fayetteville. For decades, there's been a discussion, I'll put it politely, a discussion between the city and the rural areas on when and if and who pays for the extension of municipal water and sewer lines to those areas. And I can tell you, a lot of that's in my district, that irrespective of Republican, Democrat, people have very firm opinions on that in the unincorporated areas of the county, which are different than the voters in the incorporated areas. I mean, that's just one thing. Fire protection. Rural fire districts are very important. Every once in a while we have bills up here that we're talking about rural fire districts and how this goes and that goes. These are the issues at the local level where people live that unite people and things. And however this would come out, and I'm not necessarily against any of these bills, but I would need to see groups defined much better than this so that folks who live in rural areas would not inadvertently be discriminated against in drawing of districts. If this were a menu in a restaurant and you can pick one from column A, one from column B, and one from column C, there are parts of all 3 that I like. Unfortunately, they don't all fit in the same bill. So I'm just bringing this up because I think that sometimes, and just for the record, I do have a master's degree in operations research, which essentially is applied statistics, so I know numbers. I think we get wrapped up too much sometimes in the numbers and trying to find the best number that fits on any one of these tests, and we all are applauding ourselves when we get either the highest or the best number that fits. But it doesn't recognize reality on the ground as it is, where constituents have real issues that affect their daily lives that has nothing to do with party affiliation, but has to do with where they live. So as we move forward in this, I would just like some recognition of that fact to be put in these bills. I don't know how to do it, but I'm bringing it up because I feel it's very, very important. Thank you.
Thank you. Representative Harrison is recognized for a question or comment.
Thank you, Mr. Chair. I wanted to extend my thanks to Representatives McGrady and Warren and Reeves and all the others that have sponsored these bills. I think it's very important that we move towards an independent redistricting process, and I appreciate the chair calling this meeting to consider these bills. We have another alternative besides these three that several of us have filed, which is House Bill 827, which proposes a independent citizens commission. And I hope that we'll consider some of those options as we move into actually developing a plan. Specifically, probably directed to the staff, the question about House Bill 140 that proposes a constitutional amendment. Just to clarify, the North Carolina Constitution would be amended from sections 1 through 3. That would all be included in our Constitution.
Yes, ma'am. The sections 1, 2, and 3 of the bill would be included in the Constitution. So section 1 and section 2 are basically conforming changes to direct the drawing of House and Senate districts at the state level to what would be the new redistricting provision within the Constitution. The Constitution would set out the redistricting standards that Jessica illuminated in the chart. Also would say that the process, it would set a few criteria for that, saying that all data and methodology used in the legislative drafting of electoral districts for consideration by the General Assembly must be made available to the public 5 legislative days prior to the introduction of a plan. 1 or more public hearings must occur between the first and second reading of a bill in each house of the General Assembly, provided the public hearing occurs no sooner than 5 legislative days after the first reading, and there must be at least 10 legislative days between first and second reading of the bill in each chamber. And lastly, it authorizes the General Assembly to establish a redistricting commission. Section 6 of the bill, which starts on page 3, line 25, would provide those statutory provisions that the General Assembly would be authorizing a redistricting commission.
The lady's recognized to
Okay, I
continue.
had a couple of follow-ups. Just so to clarify, there probably wouldn't be necessarily any implementation legislation as we had with like voter ID, for instance. It's all in here.
Yes, ma'am. This is all rolled up into one bill so that it would be voted simultaneously by the General Assembly.
May I follow up?
Please.
So the actual drawing of the map, because we heard a lot about that during the most recent process, is the actual drawing of the map that's proposed in 140, is that done in public?
The bill is silent as to that. It would leave to the Temporary Advisory Commission to set the process that the Legislative Services Office would use. So that Temporary Advisory Commission, by the constitutional provision and the implementing statutes, could choose as a policy that it be done in public. It could allow that to happen, at certain points in time where this is released. It would literally be up to that Temporary Advisory Commission.
The lady's recognized.
Thank you. And I'm not up to speed on redistricting law, but I'm wondering where communities of interest fits in here, because I represent A&T's campus, and they're still very upset about having the congressional district split. Their campus being split between 2 congressional districts. I'm just wondering where it factors in. I don't see it in the proposed criteria. And
Mr. Chair,
Please.
so the communities of interest concept came out of the Stevenson v. Bartlett decisions that are at the state level, and they're interpreting the state constitution. And I think kind of in general how it's been applied is very similar to the comments that Representative Szoka was making about other persons and groups. That there's some determination as to whether or not there is a sufficient cohesiveness to be a community of interest that should be kept together, or something else, that a policy decision is made as to that. But there is no specific statutory definition or constitutional definition of community of interest that I'm aware of.
The lady's recognized.
thank you. I think I just have 2 quick questions. In any of these, is there a proposed hierarchy for the criteria? Because at some point you're going to have conflicts between contiguity or compactness or whatever. So.
At this juncture in time, none of these current editions of any of these bills propose a hierarchy for the criteria.
The lady's recognized.
Final question. Thanks for your indulgence. Specifically with regard to House Bill 140, the criteria that are used in redistricting, Section 3, Section 25, subsection E on page 2, line 32. That's, I guess, the whole county's language out of Stevenson. Is that just the language that was in that case? I'm wondering about the county cluster issue, and is that something that would propose to be redrawn every time we go through the redistricting? Would this put the county cluster into our constitution?
Yes, ma'am. So the language, we'd have to go back and determine if it's word for word what came out of the Stevenson v. Bartlett opinions for you. But the concept, yes. What would be proposed as the new Section 25(1)E would be addressing the issue of clustering and how the General Assembly should go about doing that.
And just to be clear on that, Ms. Churchill and Representative Harrison, when you say county clusters, that's what I would refer to as a county grouping. Is that right?
I apologize.
No, I just want to make sure we're talking about the same thing. Representative Hawkins.
Thank you, Mr. Chairman. Can be approved for, acknowledged for 2 questions.
Please, the gentleman's recognized.
Okay. Related to House Bill 140, we talked about if a constitutional amendment was put forth and approved by the voters, that ratification would have to happen in the General Assembly. What changes could be made after it came back to the General Assembly?
So, Mr. Chair.
Please, Ms. Churchill.
The constitutional provisions, if they are approved by the voters of the state, are engrossed into our Constitution. The only way those constitutional provisions could be changed would be by further act of a vote of the people. So within the bill, starting on page 3, line 25, which is Section 6, those would be statutory provisions.
Statutory provisions.
Those statutory provisions could be changed by any future General Assembly at any time.
Thank you. That's what I was asking. I appreciate that. With House Bill 69, we specifically talk about the state auditor would verify that each nominee is eligible for appointment and then randomly select. What sort of oversight would the General Assembly have in verifying, approving what that process is?
So, Representative Hawkins, there's nothing in the bill that would alter current processes for General Assembly members. There's nothing in the bill that would make that process confidential either. So it would, whatever the state auditor did, whatever the State Board of Elections did to verify voter registration or qualification, that would be a public record in that agency's hand. Even if it were not, even if it were some sort of confidential piece of information, any member of the General Assembly can ask for a state agency for that confidential information. Please note that if you get that confidential information, you have to treat it as confidential. But in this particular instance, there's nothing confidential. That process would be a public record and anyone could ask for it.
Thank you.
Representative Sauls.
Thank you, Mr. Chair. Excuse me. On the approval of plans, House Bill 69 and 648, one has a commission vote of 8, the other 6. What would happen if you had a stalemate of 4 or 3?
Representative Sauls, those numbers are determined by the majority vote of the commission. So the actual numbers, the makeup of the commission for both of those is different. One has 11 members. Well, actually, they both have 11 voting members. So if there is not a majority vote, nothing would happen. It just would not be approved by the commission. So the process of drawing the plans would just continue until there is that majority vote in place.
Representative Queen, did the gentleman have a question? Members, as you continue to think of any additional questions for the time that we have remaining here, the chair would put this out there for your consideration. The next time we meet, the chair would like to hear about different reform ideas that have come perhaps the Iowa or Ohio model. Perhaps we could reach out to NCSL or another group. Actually, we tried to do that for this week, but we were a little bit slow on the draw there. And to hear what they have done, I think from the nature of the questions that have already been asked, we've come to understand that this is a very serious topic. The reason there are multiple bills here, and even more bills that have been filed, has just been made aware by Representative Butler. We want to get this right if we're going to do this and pass this this reform, and hope what had been part of the goal of today is to understand the differences between a constitutional amendment and a statutory change. We all need to be mindful that no General Assembly can bind the next in regard to what a statutory change is. Doesn't mean that's not a good way to govern. We just need to understand that that is the nature of the way things work. I also, the chair did have one additional question that I think I know the answer to, but I want to be sure. Any bill that is passed that changes the statutes in regards to the redistricting process would be subject to gubernatorial veto. Is that correct?
Absolutely. The gubernatorial veto applies to any public bill unless exempted by the Constitution. The North Carolina Constitution currently exempts a legislative or congressional redistricting bill containing that plan and no other matter. So if there are any statutory changes to establish a redistricting commission, that bill would be subject to the veto. I would note that any constitutional amendment is also, any proposal for a constitutional amendment containing no other matter is also exempt from the veto. House Bill 140 would be subject to the veto because it does have the implementing language in it to amend the statutes.
Representative Queen, the gentleman is recognized for a question or a comment.
Thank you, Chairman Lewis. My comment and question is about redistricting in general. We have also in front of our state a lawsuit on our congressional districts going along at this present time, and I think we're anticipating some sort of ruling that we will have to deal with in this redistricting committee. And being from Western North Carolina, I don't want to get in the same situation we got in the last round of Senate and House districts, to where we couldn't have public input properly considered. I really think we as a committee need to consider how we can have some public input on the likelihood that we will be hearing congressional redistricting mandate here shortly. So I would ask the chair if he would ask staff to look at a plan that would consider public input on those congressional districts if we have that brought before our committee here in the next few weeks, because time will be of the essence, and we can do a little planning now and make that much more public friendly than we did last time. And again, being from the far west, having a district that's one of the most egregiously gerrymandered, we really are interested in having some public input. So I would ask the chair to consider that and come up with the plan. We can, approve it in this committee and have it ready in the case that we indeed are challenged to redraw our congressional districts before we get out of here.
Thank you for your comments, Representative Queen. As that was directed to the chair, I will respond. Your points about directing staff to begin the process of what it would look like to take additional public input is well founded. that is a reasonable conversation that you and I can each have with staff. The chair would point out that based on the last court ruling that we received, we were not actually allowed to give staff any instruction that was not done in public. So it is a difficult challenge to predict what the outcome or to anticipate what the outcome of the current trial will be. The chair would also ask the gentleman to please keep in mind that we are here to discuss a way to better draw lines. Words like egregiously gerrymandered do not necessarily lead to a collegial conversation, because the pushback to that would be that the current congressional plan keeps 87 of our counties whole and splits only 12 precincts in the state. So I guess beauty is in the eye of the beholder. Does the gentleman have an additional question or comment?
I think, I guess I come from the West, and that's my congressional district, so I'm maybe more opinionated than I might ought to be. But I do appreciate us looking at the very issue of public input. It's been part of all of these we've just heard from. I think we can anticipate that and do it in an equitable way across our state, whether it's regional or congressional districts or whatever. But I think if we don't start planning on it, we're just going to hear that we can't do it because of time. But right now, I think we could consider a reasonable bipartisan way to include public input across our state, because our citizens are deeply interested in this issue. And so I just ask the chair's engagement in that. It needs to come out of this committee. It's our charge to do this process openly and fairly, and I think we can do better than we did last time. I think we can learn from what we've done. We have a little more time. We have a little more warning, and this is not something I think that would bias in one way or another. The process, public hearing, we are very familiar with on everything we do at this level of policy engagement. It's very important to have it. So I just ask your indulgence in developing a plan ahead of time.
The gentleman's concern is duly noted. Representative Torbett, then Representative Harrison.
Thank you, Mr. Chairman. I just was sitting here thinking that, we're, I guess, diving into this pretty deeply as we look into the future of how lines will be drawn in North Carolina, and we seem to be missing things. I'm hearing one half, I guess, of the debate. And can we also incorporate into the dialogue and discussion within this committee reasons why over half of 50 states actually do not use any kind of commission? I'd like to hear some of their reasoning, some of the content as why they have opted not to or choose not to, as to work parallel of looking into having a commission. I would feel like we get more of a balanced look at that. Thank you, Mr. Chairman.
Duly noted. Representative Harrison.
Thank you, Mr. Chair. I would just, as we were looking at other state models, I know it's kind of the third rail around here, but the California Commission, Citizens Commission, actually has been very successful in that state. That's a heavily blue state, and it's the approval rating of the legislature was something like 8%, and then the citizens put a ballot initiative. They established a Citizens Commission. The approval rating for the legislature is now above 50%. It's very collegial, bipartisan, much more bipartisan post-citizen redistricting. So I hope that we'll just look at their model as an option too. Thanks.
Noted. Representative Hawkins. The gentleman is recognized for a question or comment.
Comment. I thank you, Mr. Chairman, and others for pulling us together related to the potential for nonpartisan redistricting and having an open dialogue. But I do think that, not to get too deep into a conversation, I want to make sure that I'm clear about where I am on this in a collegial manner with my colleagues, that I will not support any effort that does not have public hearings. So that's just so that the remainder of my colleagues on the redistricting committee know where I stand, because I know that we're going to start inserting our red lines and those sorts of things. I want to make sure that in a collegial manner my colleagues do know that. Thank you.
Representative Hawkins, your concern is duly noted. This is one of the things that I hope we can talk about as we move forward. Let's get real quickly, if we could, an inquiry to staff. Would you tell us what the statutory requirements for a public hearing are?
So I think, again, the answer might make a bit of a difference as to who is conducting the public hearing. If it is the North Carolina House, North Carolina Senate, and a committee thereof, that is controlled by the rules of each chamber. Generally, it's give notice just like you would for a committee meeting notice at this time under each chamber's rules. If you were talking about the city of Raleigh or the county of R-Harnett, again, it's part of one of their regular commission meetings. What type of notice might be required may determine by the statutory requirement that they're having the public hearing, or whether or not they are optionally holding one.
Right.
Follow up, Mr. Chairman.
Before you do, the reason I think it's important that we consider that in all of our conversations is there have been times when we've been called upon to redraw in a shorter time frame, and we need to make sure that any requirement of the public notice under the normal course of things would take into account that it may be a compacted time frame. But the gentleman has the floor and may continue.
Absolutely. I was duly noted on that, and it's very reflective of what we just went through in the last round. So you're exactly right, and I did understand, having gone through that process, how it does impede if we have a short and compact time frame. The question that I had, and this, Mr. Chairman, if I could direct it to staff, is if we find ourselves in a space where we need to change the rules, would we then put forth a resolution to amend the current House rules?
Yes, Representative Hawkins. If it is a rule of the chamber that is controlling public hearings, calling of conduction of public hearings, then the rule could either be suspended or changed by that chamber, but it would be up to the chamber to act to do that.
Representative Brockman and then Representative Torbett.
Thank you, Mr. Chair. And I also wanted to be on record for thanking the chair and leadership for bringing forth these bills for us to hear. I do have one question. Do you have a timeline on when we may be able to vote on these bills, or a bill?
At this time, I don't have a timeline. One of the conversations that I've had with staff is that we need to make sure that we get this right. One of the bills contemplates a vote of the people at the primary in March. If we are going to accommodate that timeline or go down that model, we would need to devote time to getting it right. I am committing to you that I intend to do that I intend to work on this and to get a proposal that can truly vet the concerns that have come up in here today, and also concerns from people that are outside this room. Again, we're trying to find a system that works a little bit better than it has in the past. It's a bit too premature right now to say, I think we can vote on this bill by the end of the next month, but I do hope we come up with a bill that makes sense.
Mr. Chairman.
We'll come right back to you, Representative Butler. Representative Torbett.
Thank you, Mr. Chairman. I'd like to also join my friend and colleague, Representative Hawkins, with the public hearing comments that he made, and just also to take us back in history just a bit of time. I guess my caveat would be to absolutely have those throughout the state if the courts allot enough time to properly plan and initiate. Because I do remember back some years ago, and I'm sorry I do not remember the year, under your leadership, I believe, we went across the state and had numerous public hearings. I know that because I think I led the one in Mecklenburg at the time and had great turnout and wonderful feedback from the public, and I actually look forward to those meetings. But I think if allotted, because I hate to leave here with the people hearing thinking that there's a want to not have public hearings. No, actually, totally in the reverse, 180 degrees. There is the want and the will and the desire to have public hearings, to hear from the people that we represent when given enough time by the courts. So I just wanted to add that. Thank you.
Representative Butler is recognized for a question or comment.
Thank you, Mr. Chairman. Comment. I very much like the way staff or whomever is responsible for organizing this chart. I think it is very helpful. And I think as we approach this collectively as a well-intentioned group, as we analyze, for example, the method, viewing these various bills as a menu, I think maybe Representative Szoka might have used that term, viewing these various bills and perhaps 827 as well, using it as a menu to discuss methodology, number one, across each of those bills and choosing what we believe to be the best component under that category. And then moving to the application and to how a commission, if we choose one, is established. I think we have a lot of choices across these 4 bills. And for us to debate and discuss each category and what's the best approach for each objective in each category is well suited. So I applaud whoever came up with this idea, and I think as we debate each of these sections, as you will, we may come up with the best choice or the best methodology under each category. So I appreciate that.
One bit of housekeeping. After we adjourn, would you please make sure this is added to the committee website so folks can see it if it's not already been done?
Absolutely.
So, are there any further members seeking comment or question at this time? Representative Warren or Representative McGrady, did the gentleman wish to add anything at the end of the meeting?
The only thing I'd add is when we end up with a bill, and I've always, Representative Reeves and I believe that neither of our bills are perfect. We were just trying to put out some options. Looking at those criteria are really important. And the one issue that 140 covers more than the others has to do with sort of the concept of big data. There's a lot of things that are not political that can be used in a political fashion. We've gotten much more sophisticated with it, and I do think that's something that is going to have to be addressed in whatever the bill that goes forward. Thank you, Mr. Chairman.
Representative Warren.
Thank you, Mr. Chair. As I said in my overview, the one thing I would like to go back and emphasize in my presentation or in this proposal is the section on public opinion, public input. Going through the normal committee process, as I've seen over the years being here, particularly when it comes to the fisheries, the marine, everything out on the East Coast, we've always put aside. In fact, I remember sitting here one time for 4 hours taking public comment, and that's what I had in my intention when I was talking about going through the committee process. I joined Representative Torbett in emphasizing how important that is to get public input on what we're doing, particularly when it so intimately affects people's lives. So I certainly would, as Representative McGrady said, I don't think any of our bill proposals are perfect, but they are a step in the right direction. And adding on to Representative Butler's comments, I think we have laid on the table today 3 proposals that we can pick and choose from and maybe forge a wonderful process better than what we've been experiencing this past time.
So the chair is going to, Representative Queen's recognized for a question or comment.
I just want to applaud your comments that we would include some other models. We've got some other bills and some other models nationally. Our purpose here is to build trust with our public, that they know they will get an opportunity to select their legislators and their congressmen. We want to, that is our goal. So if we're open to ideas, test the best practices, realize we're in a new world, as Representative McGrady said, of big data, and things have changed, but the citizens want their vote to be equal and matter, and I think if we will conduct ourselves in this inquiry, we can come up with some principles to build trust in our system, and I look forward to working with everyone in that regard.
Seeing no other further member seeking recognition, we'll invite our staff to return to their posts. The chair would point out some takeaways from today that we want to try to follow up with. I think Representative Szoka is concerned about what the word groups means. I think that's something that we need to be able to address next time. The Representative Harrison's concerned the drawing of the maps in public. What exactly does that mean? Trying to define community of interest. What does that mean? Is there going to be a hierarchy of criteria, or they be balanced together? The big data concern, very interesting. The importance that several members pointed out of feedback from the public, and also what the federal requirements are on this state as it draws its maps, and of course states what methods are used different from ours in other states. But the chair does thank all of the members for their time today. We thank those who took time to attend this meeting and engage in this process. And we have no further business. We stand adjourned.